It's 9:07 by the court's clock. The first case is scheduled at 9 o'clock. We do not have any of the 9 o'clock defendants here as of yet. As soon as they are available, we will begin to call the cases.
The person with the name of Shelby's phone, can you hear me?
I might, Mr. O'Connell, I might, if I can, speak with the prosecutor for just a second.
Okay.
And then I'll get back with you. I don't think it's going to change our decision, but let me at least talk with the prosecutor.
Do you want a breakout room?
Yes, please.
Okay.
Yes, please. Oh, I finally get to see Miss Fortier. I
Good
remember
morning.
you. Now you said you had long hair.
When we first met, I had very long hair. I got a bit of a cut.
Looks nice, flattering. Mary Ann?
Jeff, you know what? I
Yeah.
just looked at my, before
Yeah,
you
go
go
ahead.
in there with, before you go in there with him, I just looked at my notes. It would be no assaultive contact, not no contact in general.
Oh, all right. Is the no assaultive contact in order as we speak? Has that been amended in any way?
I'm sorry?
Has the no contact order been amended as we speak?
I'm not sure. I don't believe so. I would be open to amending today if we don't resolve to a no assaultive contact.
All right, thank you, ma'am. Mary Ann, could I go back into a breakout room with Mr. O'Connell briefly?
Sure.
Mr. O'Connell, we're going back into a breakout room
Okay.
where we were before. Just join and we'll talk.
All right.
Good morning. Calling 210009. State of Michigan versus Jesse Catron O'Connell.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. O'Connell. Your Honor, today is the date and time set for a pretrial in this matter. I've spoken with prosecution. I've spoken with Mr. O'Connell. At this time, Mr. O'Connell wishes to take the mercy of the prosecutor and plead guilty to the charge of domestic violence with the understanding if he complies with all the court's wishes, the court will consider a dismissal of these charges after a period of 1 year. Also, with conversations with Ms. Fortier, it is agreed upon that the no assaultive contact will be changed, or the no contact will be changed to no assaultive contact with Megan O'Connell. True, Mr. O'Connell?
Yes.
Your appearance, Madam Prosecutor.
Good morning, Darian Fortier on behalf of the people.
Thank you, Madam Prosecutor.
Fortier, you heard the comments made by Mr. Bowditch this morning.
Yes, Judge, they are correct.
Your name for the record, sir, in the red sweatshirt.
Jesse Catron O'Connell.
Mr. O'Connell, you heard the comments made by your attorney this morning.
Yes.
It's alleged that on January 11, 2021, you committed the crime of domestic violence
Yes.
in the city of Huron Township. Your attorney has indicated for the record that you and the prosecutor have agreed that you will tender a plea of guilty to the charge of domestic violence, that matter will be taken under advisement for a period of 1 year, and that if you don't incur any new offenses, the matter will be closed out successfully.
Okay.
Knowing all that, how do you wish to plead in this matter?
Guilty.
Judge, I'm sorry.
I'm
I don't
sorry.
mean to interrupt. I just so that is clear, that also includes batters counseling. I just want the record to be clear, Judge. Sorry.
Mr. O'Connell's aware of that, Your Honor.
Well, before he responds, is there anything else?
No, Judge.
No, that's okay. Batterers counseling and 1 year under advisement, correct?
Yes, Judge.
Okay, Mr. O'Connell, if you are to plead guilty in this matter, you will give up your right to have a trial of any kind. You'll give up a right to call witnesses against you in your defense. You'll give up a right to cross-examine any witnesses put forth by the prosecution. You understand that?
Yes.
You'll also give up your right to testify or remain silent at trial.
Yes.
Knowing all that, how you wish to plead in this matter?
Plead guilty.
Okay. Your plea will be accepted under advisement so long as you don't incur any new offenses and successfully complete batterers counseling. This matter will be dismissed in 1 year.
Okay.
As
Thank
to
you,
the
Your Honor.
fines and costs, was there any conversation between the parties?
No, Judge, I don't believe there's any restitution in this case, so nothing from the people.
I'm gonna step off for just 1 second. Parties will stay put, don't move, okay?
Yes, Judge.
Okay.
Yes,
Thank
Your Honor.
you. Thank you for your patience. Mr. O'Connell will be assessed a $500 fine. There's also state cost of $50, fund fee of $20, crime victims fee of $75. I haven't done the math on that.
I have a question, Your Honor. May I be able to pay it out to probation, like a payment
Yes,
plan?
sir.
Okay.
Judge, I do believe if my math is correct, and again, I went to law school, 645.
It is 6:45. Mr. O'Connell, you can contact our collections department and make arrangements unless you can tell me right now what you can pay and how often you want to pay, and then we can set out a payment arrangement.
I can do $100 a month.
Starting when?
In the next 2 weeks.
So today is the 9th. If I make your first payment on the 23rd,
All right. That'll work.
is that realistic for you?
Yes.
Okay, I'll have the collections department send out a payment agreement letter.
Okay.
Anything else? Ms.
No,
Ford?
Your Honor, thank you.
Nothing from the people, Judge. Thank you.
Thank you. We're all set
Thank
in
you,
this
Madam
matter.
Prosecutor.
You're all set, Mr. O'Connell. Thank you for your patience this morning. Mr. Bowditch, two of your other defendants are here this morning. I'll have Mary Ann pull you into a breakout room if you would like to speak to. Next up is Thomas Cheatham,
Yes, Your Honor.
and she'll pull Mr. Cheatham in and put you into a waiting room, into a
Thank you, Your
breakout
Honor.
room. Thank
Thank
you.
you, Your Honor. Hi, Mr. Cheatham. We'll talk in a second. They're going to
Okay.
send us into a room we can talk privately.
Mr.
Okay.
Bowditch, you do have the offer on Mr. Cheatham's case, correct?
No, ma'am.
It's 769 plus a psych evaluation, batters counseling, no contact except for the child in common, and restitution of $274.18.
Thank you, ma'am.
Yep.
I'm sorry, Mr. Cheatham, I'm sorry, Mr. Bowditch, before you go into a breakout room, on the last matter, 210009, the parties asked to amend the bond to be no assault of contact with the complaining victim.
Yes, Your Honor.
I don't think I officially said it on the record, but that his bond will be amended to
Thank
no
you,
assault
Judge.
of
Thank you.
contact.
My apologies, Your Honor. I forgot.
That's my apology. That's my oversight.
Thank you, though, Your Honor.
Thank you. And are you ready to go into a breakout room?
Yes, Your Honor. I'll be joining
Okay.
now.
Thank you. Mr. Bowditch, are you ready to proceed in this matter?
Yes, Your Honor. If I could just make a comment to Ms. Fortier. Is she still with us?
She is.
I'm here.
Ms. Fortier, would the malicious destruction of property be dismissed? No, there will be restitution, but will the second charge be dismissed?
Yes, that's my understanding. Yes, plead to DV and then the MDOP will be dismissed.
Your Honor, I believe we're ready to proceed.
Calling 201169, State of Michigan versus Thomas Andre Cheatham.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. Cheatham.
And Darian Fortier on behalf of the people, Judge. Good morning.
Good
Your Honor,
morning.
today is the date.
Just Mr. Bowditch, my apologies. This matter is being streamed live over YouTube. The alleged victim in this case is also present. I've asked her to stay muted.
Yes, Your Honor, Ms. Morgan.
Thank you.
Your Honor, today is the date and time set for a pretrial in this matter. I've discussed the matter with Mr. Cheatham. I've discussed it with prosecution. We have an executed plea agreement subject to court approval. In that agreement, Mr. Cheatham would be pleading guilty to the charge of domestic violence, with the understanding the companion charge of malicious destruction of property would be dismissed. Also with the understanding, if Mr. Cheatham complies with all the wishes of the court, after the expiration of 1 year, the court will consider dismissal of these charges.
Ms. Fortier,
Judge, that is a correct recitation of the plea offer in this case.
and there is a written plea agreement.
Judge, I don't have a written one, but I can send it to the court.
Thank you. Your name for the record, sir, with the white headband?
Thomas Andre Cheatham.
Mr. Cheatham, you heard the comments made by your attorney this morning?
Yes, ma'am.
Sir, it's alleged that on June 11th, 2020 in Huron Township, you committed the acts of count 1, malicious destruction of personal property, and count 2, domestic violence. Both of these are misdemeanors. Your attorney has indicated this morning that the people have extended the offer of dismissing count 1, malicious destruction of property, and that you will tender a plea of guilty to the count 2, domestic violence. Do you understand that?
Yes, ma'am.
And you wish to accept the plea of the people?
Yes, ma'am.
You understand that if you accept this plea, you will not have a trial of any kind, that you'll give up the right to have witnesses called in your defense. You'll give up the right to cross-examine any witnesses put forward by the people, that you'll give up your right to testify or remain silent at any trial, and that you give up the presumption of innocence in this matter.
Yes, ma'am.
Knowing all that, you still wish to plead guilty.
Yes.
Mr. Bowditch, the factual basis for your client's guilty plea.
May I voir dire, Your Honor?
Yes, please.
Mr. Cheatham, I want to ask you a question. This is what we explained is on the record. Did on that June date in 2000, June 11th, I believe, 2000, did you either put Miss Morgan in fear or offensively touch her?
Yes.
Defense is satisfied, Your Honor.
Anything else from the people?
Judge, I just wondered, does it matter that the defendant wasn't sworn in?
It does matter. Thank you, Ms. Fortier. Would you raise your right hand, Mr. Cheatham? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Mr. Bowditch?
Once again, Your Honor, Mr. Cheatham, did on June 11th, 2000, did you either put your Miss Morgan, the mother of your child, in fear or offensively touch her?
Yes.
Defense is satisfied, Your Honor.
Thank you.
Satisfied, Ms. Fortier?
People are satisfied, Judge.
Yes. Were there any other terms of the plea agreement between the parties?
No, Your Honor.
Okay.
Oh, there is restitution, Your Honor, of $274.18.
Yes, Judge, and also a psych evaluation and batterers counseling, which I believe was mentioned.
Yes, Your Honor. And mention to Mr. Cheatham.
Batterers counseling and psych evaluation.
Yes, Your Honor.
Was there some discussion about who would in fact complete the psych evaluation or perform it?
No, Judge.
Or a deadline to have it done?
Judge, honestly, I think you're the first judge that's asked me that. I guess my opinion would be as soon as possible so that if there's any recommended treatment that can be done, before hopefully, I guess, before the 1 year is up, or at least started before the 1 year is up. Unless Mr. Bowditch has a different opinion than me.
No, Your Honor. Again, first blush with me also, counsel. I think probation will make those arrangements.
Probation will make the arrangement. Okay. I wasn't sure how that would happen, how that.
It'll be scheduled through probation. They'll give him guidance on how to do it.
Thank you, Mr. Bowditch. So the court will assess the restitution of $274.18, crime victims fee of $75, state costs of $50, building fund of $20. There's a $50 warrant fee and a fine of $500. That's $969.18. Mr. Cheatham will need to report to probation for these other matters. I don't know that I actually said that his plea is accepted with the conditions that were put on the record by the parties, which include matters counseling and the psych evaluation.
Your Honor, may he set up a payment plan through collections?
He can.
Thank you, Your Honor.
We have a phone number for Mr. Cheatham that ends in 5814. Is that a valid phone number for you still, sir?
Yes, ma'am.
Okay. Anything else in this matter?
Judge, just two things. At this time, the people would move to dismiss count one. And I would ask that if Ms. Morgan does wish to say anything, she be allowed that right.
Ms. Morgan, raise your hand if there's something you'd like to say this morning. Ma'am, what is it that you'd like to add to these proceedings?
I was just wondering about the no contact order violations that Thomas has violated. The most recent one was on January 30th at 2:38 a.m. He did send me a text message. This is the 5th time since June the 11th.
Judge, if I may just note, I am aware of that contact, and it's my understanding that there is a no contact order as part of the plea. So I, at this point, would just indicate that somebody give Mr. Cheatham a warning that if that contact violation, or if that contact order is violated, that that's a probation violation, and he could potentially be taken into custody.
Mr. Cheatham, did you hear the comments made by the prosecutor?
Yes, ma'am.
Do you understand what no contact means?
Yes, ma'am.
No contact means no contact, no direct contact, no contact through a third party. That means do not call her, do not text her, do not send her messages on social media, don't send a carrier pigeon to her house. Do you understand?
Yes, ma'am. But can I?
No, I don't. I hear you, sir, but listen, even if she reaches out to you first, or even if she sends something that you think is an invitation to communicate with her, do not contact her. As the prosecutor indicated, it will be a violation.
Yes,
Okay.
ma'am.
The agreement of the parties is that you will be trouble-free for 1 year. Trouble-free means don't violate your bond conditions, okay?
Okay.
Your Honor, they do have a child in common. I believe they exchange the child
For the
every
love of
Friday.
God.
Yes, Judge, that all this is partially my fault. It probably would have been easier had I gotten the written form to you before we did the plea. This is the first time I've been responsible for this file. The no contact order does have a caveat with the exception of their child, but I do believe that the texts that Ms. Morgan has received from Mr. Cheatham have not had anything to do with their child, which is why I believe she's bringing it up.
Ms. Morgan,
Yes, we do have a child together, but I do have so physical, so legal. The court is aware that we have a no contact order. All of our contact is through GrowthWorks. That is where his supervised visitation is. So there's really no need for him to text me involving the child. It all goes through GrowthWorks.
The order that I see in the file regarding bond says no contact. So, Ms. Fortier, are you saying that the contact is for childcare purposes only, or is there a actual no contact?
My understanding is it's no contact except through the facilitation that Ms. Morgan has indicated. I didn't quite catch the name. Is it
GrowthWorks.
I think
Yes.
that's the only contact allowed. And in regards to the child only.
So are we all on the same page now?
Yeah,
That the contact
Yes, Your
is
Honor.
only through GrowthWorks and only for the purposes of child care arrangements or child transfer?
Yes, Judge.
Thank you, Mr. Cheatham. Thank you, Mr. Morgan. Anything else, Ms. Fortier, in this matter?
Nothing from the people, Judge.
Anything else, Mr. Bowditch?
No, Your Honor.
We're all set as relates to Mr. Cheatham. Thank you for your patience. Thank you for joining us this morning, Ms. Morgan. You both have a good day.
Thank you,
Thank you,
Judge.
Your Honor.
Judge, do you want a written form in regards to the last case as well?
To the first case,
Yes, Judge.
I don't think so. I don't think that that was complicated. If you want to send it, you can, but I think that that one was pretty straightforward.
Okay.
And during the course of that hearing, I admitted 2 attorneys to the proceedings, Mr. Robinson and Ms. Belcher. I'm not sure if their clients are here to match up to proceed this morning.
Yes, Judge, my client's with me.
Your Honor, I do not believe my client will be logging on. They gave him the incorrect date at the time of the arraignment. I represent him on another case, and we have a court date next week, and I've been having a little bit of difficulty getting him on the phone. There were some phone issues, a lot of back and forth. So I'm just requesting a new date, given the fact that he was advised of the incorrect court date at the arraignment.
Who is your client?
Rodney Pfeiffer. He has another case pending, Your Honor, but that one is with his son. So because it's not a direct person like a spouse, that is with a different prosecutor. So when they arraigned him, I believe they gave him the court date for this case in front of Your Honor, but for a wrong prosecutor, if that makes sense.
No, it doesn't, actually.
Okay, so my understanding is the domestic prosecutor, Ms. Fortier, is for direct contact with like a spouse or somebody that is married to an individual or dating. If it involves a distant relative or another family member like a child, it's a different prosecutor. So he has another case that's pending with his son, and that's in front of, I believe, Judge Oakley next week.
Next week,
Or it may be Judge Green. I can check my calendar, which
I
judge.
have a note that he has a case scheduled for February 19th. Does that sound correct?
Yes, Your Honor, that is correct. And it is with Judge Oakley.
Okay. So in the matter 210027, State of Michigan versus Rodney Pfeiffer.
Good morning. Leanna Belcher on behalf of Mr. Pfeiffer.
Darian Fortier on behalf of the people, Judge.
And Ms. Belcher, before the case was called, indicated that her client was not provided with the correct date to appear on this matter for pretrial.
That is correct, Your Honor. I was called by Heather at the 34th District Court. She advised me that the wrong court date was given to my client. Since that time, I've been trying to make contact with him because this current case does involve his spouse. He has not been allowed to return to the residence that he lived at and the residence that we had an address for him. So we've been unable to mail him a new notice. He does have a court date coming up on an unrelated matter with his son. I would just ask that this matter be adjourned so that I can properly notify him of this pending case.
And did Heather indicate, you said Heather indicated to you that adjourn date for this case will be that same February 19th date?
No, she did not give me that date because it's a different prosecutor. She just notified me that at the time of the arraignment, an incorrect date was given to Mr. Pfeiffer. And she wanted me to make contact with him to give him the February 9th date and to get a different address that we could mail the new notice because he is not to return to his marital home as a condition of this bond. And I have been unable to make contact with him.
Okay, if it's not that this case is traveling with the other case, the list of dates that I have available, not that I have available, but that the court has available, has the next date of February 23rd, 2021 at 9 a.m.
That's a good date, Your Honor. The issue is just that he hasn't been notified. So as long as I can notify him, which I'm going to see him at the next hearing in front of Judge Oakley. So we've been playing phone tag, and I do know he's been having some issues with his phone provider. So I just wanted to get an adjournment so that he could get proper notification of the next court date.
I'm putting a note in the file that he will be here for pretrial on February 23rd, 2021 at 9 a.m. with Judge Green. And when you see him on the 19th, if you want to advise him with that, it'd be much appreciated. The address we have is still the Willis Road address.
That's
Are we all,
correct.
are we all set in this matter?
Yes, Your Honor.
If I
Thank
may
you so
just
much.
very quickly to direct it to Ms. Belcher. One, the paper discovery in this case still needs to be uploaded, but as soon as that happens, I'll send that to you.
Okay, thank you.
It is digital. I know you're familiar with our protective order. I don't remember where you stand on it.
I don't typically sign the protective
Okay.
order.
I'll add you to my list of things to be redacted, but still, please note, it's just me.
I know the drill. Thank you, Darian.
Your Honor, could I go into a breakout room with Miss Belcher?
Mary Ann can put you in a breakout room if Ms. Belcher is available to do that with you.
Yeah, I can-
Leanne, can we go into a breakout room for a second, hon?
Yep.
Thank you.
And Mr. Robinson appears to be here for our 9 o'clock case. Jason Williams, is that accurate, Mr. Robinson?
It is, Your Honor.
Do you need to speak to the prosecutor? Or are you ready to proceed this morning?
I do need to speak to the prosecutor.
Mary Ann can put you into a breakout room with Ms. Fortier. Mr. Murray, how are you this morning?
Your Honor, how are you feeling?
I am wonderful, sir. I do not see your client in our waiting room.
That's because he's physically to my immediate right, Mr. Harrington.
Thank
Good
you.
morning, Your Honor.
When the prosecutor comes out, do you need to speak with her or will you be ready to proceed with Mr. Harrington?
Well, I'm always ready to proceed. It really is on the prosecutor. They requested some information. I provided it to them, and I guess it's up to them what they're going to do.
So I'm going to leave you here. When she comes back, we'll handle the case that's in front of you. And then if you want to talk to her after that, Mary Ann will put you into a breakout room.
Perfect.
Thank you, sir.
Thank you.
Chat.
I'll send you a chat when I can confirm, okay?
Okay.
Judge, I just need a couple minutes.
You just need a couple minutes for what, Ms. Fortier? I'm sorry.
Before we handle Williams, Judge.
Okay. And then you have Mr. Murray queued up to speak to you in Harrington.
Judge, while I'm waiting on an answer in Williams, I can go into the breakout room with Mr. Murray.
Okay.
Good morning.
Hey, Jim. Nope.
Hey, Jeff. No. I can't hear you. You're on mute, Jeff. Hey, Steve.
Mary Ann, congratulations.
Thank you.
I heard everything went well.
It did. Yeah, thank you. It was great. Your buddy did a good job too. He didn't cry or anything.
That's good. Mary Ann, am I supposed to be joining something or?
Nope, don't ignore that.
Okay, thanks.
Yep.
I'm back, Mary Ann.
Oh, hi, Jeff. Hey, your client,
Mr.
Jones.
Jones?
Frankie Jones. Do you want to go in the breakout room?
Yes, with Ira Jones.
Okay,
Thank you.
you're welcome. Jeff, do you see the invitation?
No, I can see Mr. Jones, but I can't see the invitation.
Okay. Huh.
Mr. Jones, you're muted.
Now, Jeff, he went into it.
You want me to do it on my own?
Join the breakout room.
Sure, I think I can do that.
Yep, thanks.
Mary Ann,
Yes,
could we go back into the breakout room?
yes,
Thank you, ma'am.
you're welcome.
Mr. Robinson, I have confirmed that that is okay to dismiss the A and B and do this DV under 769.
Darian,
Yes.
can we do a no contest on that?
What's your basis?
Civil liability?
Oh, regarding the you got the other one figured out, right?
What other one?
Without that, the reason we adjourned this case in the first place.
Yeah, I think that's being handled by a separate prosecutor. We got a pretrial on that I think in March.
Okay. Yeah, I don't have an objection. That's fine.
Thank you.
Judge, I believe we're ready to go on Williams, and I believe we're ready to go on Harrington.
Calling 201524, State of Michigan versus Jason Adam Williams.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Jason Williams, who is sitting right next to me, Judge.
Good morning.
Good morning, Judge Darian Fortier on behalf of the people.
This matter was scheduled for pretrial this morning. The parties seem to have reached an agreement.
We have, Your Honor. Your Honor, in exchange for a plea of no contest to the domestic violence, the A and B would be dismissed. Ms. Fortier, I think I'm pronouncing that right, has indicated that Mr. Williams would qualify under 769. We'd like to avail ourselves to that.
Judge, that's correct with the additive of batterers counseling and no contact with Shelby Statham or Mark Statham.
No objections, Your Honor.
And again, is there a plea agreement reached by the parties, a paper form that you've sent over to the court, or is that not written up?
Judge, we just came to this resolution. I haven't written it up yet, but I can add it to my forms to send to you today if you'd like.
Thank you. Your name for the record, sir, with the plaid shirt on.
Jason Williams.
Mr. Williams, you heard the comments made by your attorney this morning.
Yes, Your Honor.
You understand that you have a right to trial in this matter. You have a right to assistance of counsel and a right to trial.
Yes, Your Honor.
But you wish to avail yourself of the offer made by the people that you will enter a plea of no contest to count 1, domestic violence, and that count 2, the assault and battery will be dismissed.
Yes, Your Honor.
You understand that if the court accepts your plea of no contest to count 1, you won't have a trial of any kind. You won't have a right to call any witnesses. You won't have a right to cross-examine any witnesses put forth by the people. You'll give up your right to testify. You'll give up the presumption of innocence in this matter.
Yes, Your Honor.
Knowing all that, you still wish to enter a plea of guilty? I'm sorry, a plea of no contest to count 1.
Yes, Your Honor. No contest.
Mr. Robinson, you have any further questions of your client?
No, Your Honor.
Anything further, Ms. Fortier?
Judge, I don't believe I have anything to add at this time.
Okay. Mr. Williams' plea of no contest to count 1 will be accepted. Count 2 would be dismissed. There is an agreement between the parties that this plea of no contest is submitted to under HIDA status, that he will receive batterers counseling, that there'll be no contact with the alleged victims in this matter.
Judge,
That-
I'm sorry to interrupt. It's
I'm sorry.
Domestic violence statute, the 769.28, not.
I'm sorry. I'm sorry.
Mr. Williams, I believe, has aged out of HIDA.
That's what happens when your mind wanders, where you're trying to write and talk at the same time. Was there anything else between the parties?
No, Your Honor.
No, Judge, my plan for the factual basis is to use the investigator's report unless Mr. Robinson has an objection to that.
No objection, Your Honor.
Was there anything else, any other agreement between the parties?
No, Your Honor.
No, Judge.
Have you sit tight for 1 second, please give me just one moment.
Hello, Mr. Murray.
You driving a Hummer out in the snow?
Oh, yeah. Best
Gotcha.
vehicle I ever had.
Yeah, I'm getting an engine, a new trans put in mine as we speak. It's been in the shop for about 8 months.
How many miles you got on yours?
That one had 276, and it was time for an engine.
You know, I got a Florida car. Mine's 12 years old. I have 120,000 miles on it.
Hey, it's still brand new.
Still brand new?
That's right.
I got a nice Florida car.
Hey, man, you're smart. You've always been like that.
You know what's the problem is, though? You can't go to a McDonald's drive-through because the windows are so small.
Yeah.
First time I got it, I told the lady at McDonald's, you can't put enough food through that window to feed my grandson.
Yeah. How old is your grandson now?
15.
Wow, that's unbelievable.
I have one
Congratulations.
15, I have one 7, and I have one 1.
Wow.
So I have 3 grandsons.
How perfect is that?
No granddaughters yet.
Keep trying.
Well, I think my youngest son is going to keep trying.
Gotcha.
I think they like this baby business.
Nice.
Hey, Jim.
Hey, how are you, Steve?
Good. How are you?
Perfect, man. Everything's going smooth.
Good. How's Meyer doing?
Good. He won the 2021 New Way National Wrestling Tournament about a month ago. So he's doing pretty good.
You're
Awesome.
kidding.
No.
Wow.
Yeah, he's a hard worker, and he's doing very well. The schoolwork could be a little bit better, to be honest with you, but it has improved since he's gone back to in-person learning.
So he's back in person.
Yeah, 2 days a week. So what's interesting is we've traveled 5 different states with the wrestling, and most of the states are fairly normal. And then you come back to Michigan, everything's locked down. I think I'm not going to call it a hoax, but an over response in my book. But I'm not a politician.
Now, how old is your son, Jim?
12.
Has he got MMA in his future?
No,
Dad won't allow that, huh?
no, I don't think that makes sense.
Ms. Fortier,
Yes.
is there an offer on Ira Jones?
Seven, 6, 9, 12 months. Matters counseling, no contact.
Thank you, ma'am. I believe we're going to set this for a bench. Doesn't look like Mr. Canty ever showed up.
Yeah, I messaged the judge. Her KPS policy is end of the docket.
Oh, we're almost there.
Thank you for your patience. Mr. Robinson, I'm going to have your client report to probation to arrange the veterans counseling. Ms. Fortier, the reason why I asked for the plea agreement is because I haven't heard from either of you how long, I'm sorry, if there have been any discussions between you as to any fines, any costs, any particulars beyond the veterans counseling and the no contact with the alleged defendants, the alleged victims.
No restitution, so any just courts and fees per the court, so like the victim fees and the court fees and things like that, but no restitution or anything.
Mr. Robinson, is anything you'd like to add in this matter at this time?
No, Your Honor, I concur.
Your client will be assessed $500 fine, $75 crime victims fee, $50 state costs, $20 fund fee. There's $100 fee for a total of $745. Your client need time to pay that?
Yeah, Your Honor, I believe there's a $500,
Right, 1,000.
well,
500 for each.
or $1,000, I believe there's a $1,000 bond on this.
You are correct. That will be applied. Was there anything else?
No, Your Honor, does Mr. Williams contact probation or vice versa?
He contacts probation. The file is going to go to them this morning. We have a phone number for him that ends in 8161.
Yes, Your Honor.
Okay.
Yes, Your Honor.
Anything else as relates to Mr. Williams, Ms. Fortier?
Judge, just whenever you're ready, the factual basis.
Thank you, ma'am.
On September 21st of 2020, Mr. Williams was at an address on Haggerty Road, which was in Van Buren Township in the state of Michigan. At that location and on that date, he was in contact with a Shelby Statham, which he had a dating relationship with. They got into a verbal argument and the verbal argument turned physical. At the time that the verbal argument turned physical, the defendant punched Ms. Statham in the face with a closed fist. And with that, the people are satisfied.
Satisfied, Mr. Robinson?
Yes, Your Honor.
Judge, and the people would move to dismiss count 2.
No objection.
I didn't think you would, Mr. Robinson.
So no contest as to count 1, count 2 is dismissed. Mr. Williams will report to probation. He has another outstanding matter in this court that's scheduled for pretrial on March the 24th.
Yes, Your Honor, in fact, I just called Heather on that. Is that a state case also, Judge? Can you tell?
It is.
Okay, thank you.
Your prosecutor should be Jane Gillis if you have any questions.
Jane, okay.
Anything else, Ms. Fortier?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Robinson?
Yeah, Your Honor, at the risk of sounding duplicitous, does Mr. Williams contact probation? Because I know you just asked for his last 4 digits of his phone number.
Probation will contact him. That's why I verified the phone number.
Oh, okay. Thank you, Judge. Good seeing
Thank
you.
you. You're all set, Mr. Williams. Have a good day.
Thank you so much.
Thanks,
Mr.
Judge.
Murray, thank you for your patience this morning in 201435 State of Michigan versus James Edward Harrington.
Good morning, Your Honor. Darian Fortier on behalf of the people.
And good morning again, Your Honor. James W. Murray, P48047. I represent Mr. Harrington, who is physically present with me.
Judge, it's my understanding that at this time, we're going to ask for a final pretrial with the caveat that the complaining witness be present.
Mr. Murray, do you mind either showing your client or having your client state his name for the record?
James Edward Harrington.
Thank you, Mr. Harrington.
Thank you.
My further understanding in speaking with the APA is that if Ms. Harrington, the complainant, doesn't appear, that the case will be dismissed without prejudice.
That's correct, Judge.
The pretrial will be adjourned to February 23rd, 2021 at 9 a.m. with Judge Green. With the understanding that the complainant will be present. Anything else, Ms. Fortier?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Murray?
No, but it was nice seeing you, Your Honor. We'll see you again, I'm sure.
Good to see you too. Have a good day. We're all set as relates to Mr. Harrington.
Thank you.
Judge.
Thank you. Mr. Bowditch, are you ready on Mr. Jones?
Your Honor, if I could, not to delay the proceedings, but could I go into a breakout room one more time with Mr. Jones?
Yes.
Thank you.
I'm going to see who Kristen's iPad is, Judge. Okay. Hi, the Kristen's iPad. Can you hear me?
Yes, ma'am.
Can you please tell me what case you're here on?
Jason Williams.
We just completed
I
that.
just missed it. Okay.
Yes.
Okay, thank you so much. I'll get a hold of the lawyer.
Okay.
Thank you.
You're welcome.
What was her name?
Kristen. It said Kristen's iPad. I don't.
All right, not one of my witnesses. Thank you. Marianne, can I have your email or judge's email in the chat so when I'm done with these plea forms, I can send them to you guys?
Absolutely.
Thank you.
You're welcome.
Mr. Bowditch, are you ready to proceed with Mr. Jones?
Yes, Your Honor. I appreciate the court's patience.
No, thank you for your patience this morning, and I'm waiting for your client to come back from the breakout room.
He may be waiting to just time out, Your Honor.
Yeah, I just forced him out.
Okay. We're good, Mr. Jones.
Are we good?
Yeah, yeah, we're good.
All right.
Calling 201-194, State of Michigan versus Ira Frankie Jones.
Ready, Your Honor. For the record, Jeffrey Bowditch appearing on behalf of and with Mr. Jones.
And Darian is here for the people, Judge.
Your Honor, after discussions with Mr. Jones, we're requesting a final pretrial in this matter, with the caveat that the defendant, Ms. Nicole Janis, must appear.
The new pretrial date will be February 23rd, 2021.
Your Honor, Mr. Janis, and I anticipated that date. I mean, Mr. Janis, Mr. Jones is going to be out of town on business from the 22nd to the 28th of the month.
The hearing will be by Zoom. Is that still not acceptable? The 23rd is still not an acceptable date?
You think, Mr. Jones, that you could do a Zoom from your business?
Is it going to be roughly the same time?
It would be the morning.
I can do that.
All right.
February 23rd, 2021 at 9:10 a.m. with Judge Green. Complainant to be present. Anything else in this matter, Ms. Fortier?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Bowditch?
Nothing, Your Honor.
We're all set. Thank you for your patience this morning, Mr. Jones. Have a good day.
Thank you, Mr. Jones. Call me if you need me.
Ms.
Call me
Fortier,
if you need me.
Yes, Judge.
there is a Brandon Hayes here. Mr. Hayes was scheduled for 9:30. It's now 10:25 by the court's clock. I would note that he has been here since his scheduled time. He is not represented by counsel, but I pulled him into the hearings room so that we could call his matter and proceed.
Judge, he's pro se or he's not represented by counsel because no one has been appointed to him yet.
He's pro se. Your name for the record, sir?
Brandon Hayes.
Mr. Hayes, how are you this morning?
I'm okay.
This is 2100049 State of Michigan versus Brandon Lee Lambert Hayes. Ms. Fortier, to answer your question, on January 26, 2021, Mr. Hayes signed a form that indicated that I choose not to use a court-appointed attorney. That was for the purposes of his arraignment. Mr. Hayes, you're here this morning for pretrial conference. Is it your intention to represent yourself, or would you like to speak with court-appointed counsel?
Court-appointed counsel.
Mr. Bowditch, are you available?
Of course, Your Honor.
Speak with Mr. Hayes. Mr. Hayes, you're going to see an invitation to the breakout room. You're going to go in there. You'll speak to counsel.
Okay.
Ms. Fortier, while we're waiting for Mr. Bowditch to come back.
Yes, Judge.
Well, I was going to call them. I was going to do the capiases, but I see. He is standing in for Miss Greer, and that would be in the Canty matter.
Judge, do you want me to pull this person who says Jory's phone? And
Would
see-
you please?
Yes. Mhm.
Judge, I will note that the next, I apologize. This was my first misdemeanor day. So next misdemeanor day, I'll just have all of the forms pre-filled out. So then that way, if they want to take the plea, I already have them. So I apologize for that.
Ms. Fortier, I think it's our first day together. So we're both making it through.
A learning curve here.
I appreciate your patience this morning, and I'm guessing that next time we're together, it will be a little bit, it will go a little bit more smoothly.
Hi, Jory, can you hear me?
Yes, yes.
What case are you here on?
Brandon Hayes.
Ooh, Marianne, could you put us in a breakout room?
Yes, I will.
Thank you.
Yep. Did you get the invitation?
I did not. There we go. Thank you.
You're welcome.
We're good, Mr. Hayes. They'll come back in and join us in a minute.
Okay.
We're still good. We're just waiting. Waiting for
All
the judge to finish up something else, then she'll be with us.
Okay.
But I'm just going to go into one of those private rooms again with the prosecutor.
At any moment. At any moment.
Hold on one second. Marianne, can we have just a couple more minutes? I'm sorry, Judge.
Yes.
That's okay.
Thank you.
Is that for me, Marianne?
No, ignore that.
All right.
Thanks.
If you bring that person in on the waiting room, they're here on canteen.
Hi, Shanae. Can you hear me?
How you doing?
Hi. Uh, your case was at 9 o'clock with Canty, correct?
Yes, Canty.
Um, I'm sorry.
I am Canty.
He is Canty. You are Canty.
Yeah.
Okay, hold on one second. Jeff, this is yours. This is a Terrell Canty.
Yes, ma'am.
So when we're done with the Hayes case, I'm going to put you in a breakout room. Is that fine?
That's fine. I'd like to go into a breakout room with Miss Fortier first, and I'll do the business for both,
Okay.
if she's available.
Yeah, she's still in a breakout room.
Then I'll join her next,
Okay.
if I can.
Okay. Wait, is this for the Hayes case or for the Canty case?
It would be for both. While I'm in the same room, I'll talk about both.
Oh, got it.
Mr. Canty, I'll be with you in a second.
Okay.
We'll be able to talk privately in a few moments.
Okay.
I'm going to talk to the prosecutor first.
Okay.
Mary Ann, is that for me to join?
No, not yet.
All right.
Okay, sorry about that. I'm back, ready to go.
Miss Fortier, I'd like to go in a breakout room with you, ma'am, if I could.
Sure.
Hold on one second.
Thanks, Mary Ann.
You're welcome. Do you see the information? Jeff?
Yes.
Okay.
Do you want me in breakout room 4, Mary Ann?
Yes.
Okay.
Thanks.
You still need to speak with Mr. Canty, Mr. Bowditch?
I still need to speak with Mr. Canty. I think we're ready on Mr. Hayes.
Okay.
Yes, sir.
Mr. Hayes, we're going to, as you requested, we're going to adjourn this matter. There's a little bit of investigation that I'm going to do, and then we'll get together when the judge gives us another date.
Okay.
It'll probably be in a couple weeks.
Okay.
But in the meantime, I'm going to get some information from the prosecutor. We're going to talk, and well, then we'll go from there.
Okay.
Calling 210049, State of Michigan versus Brandon Lee Lambert Hayes. Your appearances,
Ready, Your Honor.
please.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of with Mr. Hayes.
Good morning, Your Honor. Darian Fortier on behalf of the people.
Your Honor, at this time, this was my first blush with Mr. Hayes. In speaking with him and in speaking with the prosecutor, there is a little bit of work we need to do. We're requesting an adjournment in this matter.
The adjourned date is February 23rd, 2021.
Judge, I'm sorry. Can we start putting stuff on the 9th? I'm up to like 35 things on the 23rd. The 9th of March, I think would be the next misdemeanor day.
Mary Ann's just going to check that date because
Okay.
I don't have the calendar with me right now.
Thank you.
March 9th. March 9th with Judge Oakley at we will say 9 o'clock for now as she checks, Mary Ann checks the schedule to see what else, how many are already scheduled for March 9th.
Thank you.
Thank you,
Judge.
Your Honor.
Mr. Bowditch, you need discovery, correct?
Yes, on that, on Mr. Hayes, I do, yes. And I need a breakout room with Mr. Cantor.
Marianne, are you checking the 9/4 time? Thank you.
Okay, Judge, so I
9
have,
o'clock on March 9th.
thank you,
For
Judge.
Mr. Hayes, Ms. Fortier, do you have anything further for Mr. Hayes?
No, Judge, nothing further from the people.
Mr. Bowditch, anything further?
Nothing further, Your Honor. Thank you, Mr. Hayes. Thank you,
We're
Your
all
Honor.
set. Mr. Hayes, have a good day. So after Canty, we still have Thompson, Johnson, and Colazzo, who have failed to appear this morning. So Mr. Bowditch, after you talk to Mr. Canty, if those other defendants have not appeared, KPs will issue. Mary Ann's going to move you and Mr. Canty into a breakout room.
Thank you, Your Honor.
Thank you.
Mary Ann,
Yes, ma'am.
do you have a phone number for Mr. Robinson from Mr. Williams' case?
Let me look it up. Hold on one second.
Thank you.
Yep. Darian, it's 941-1920.
Is that 313?
I'm sorry, 734.
Thank you.
Yep.
Judge, I just got off the phone with Mr. Robinson. There apparently was the woman on the iPad was the victim in the Williams case, and there is apparently restitution. So Mr. Robinson is going to jump back on if possible to address that.
Thank you, ma'am.
Thank you.
Calling 210008, State of Michigan versus Terrell Jermaine Canty.
Ready, Your Honor.
Good morning, Your Honor. Darian Fortier on behalf of the people.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. Canty. Your Honor, after discussions with the prosecutor and Mr. Canty, we're requesting a final pretrial in this matter. We're hoping that we can get a final pretrial, and if the complainant doesn't appear, the court may consider dismissal of the charges.
Judge, I would ask that one is set on the 9th as well.
Yes, Ms. Fortier, March 9th, 2021 at 9:10 a.m. with Judge Oakley, complainant to appear. Anything else, Ms. Fortier?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Bowditch, as relates to Mr. Canty?
Nothing, Your Honor. Thank you, Mr. Canty. Thank you, Your Honor.
We're all set. Have a good day, Mr. Canty.
March 9th at 9:10, Mr. Canty.
While we're waiting for Mr. Robinson to come back on, we also have 210051, State of Michigan versus Keith Bernard Thompson. This matter was scheduled for pretrial this morning at 9 a.m. Mr. Thompson has failed to appear. It's 10:52 by the court's clock. I would note that he did have the assistance of MIDC at his arraignment. Ms. Fortier?
Judge, at this time, the people would move for a capias.
Bench warrant shall issue in this matter, 5,000, 10%. There was also the matter of 210045, State of Michigan versus Edward William Collazo. This matter was scheduled by 9:20. It's now 10:53 by the court's clock. Defendant failed to appear. Bench warrant shall issue in this matter, again, 5,000, 10%. Last is 210013, State of Michigan versus LaRon Manuel Johnson. This matter was scheduled for pretrial at 9:10 a.m. The defendant has failed to appear as scheduled. Bench warrant shall issue in this matter, 5,000, 10%. I see Attorney Steve Robinson in the waiting room. I'm going to readmit him on the matter of Williams. Mr. Bowditch, do you have anything further with us this morning?
No, Your Honor, but I'll hang around
Thank
for
you,
a couple
sir.
minutes to see if anybody shows up.
Yes, sir.
I'm gonna mute you.
Recalling. Recalling 201524, Jason Adam Williams.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Jason Williams. Judge, I changed into my play clothes, so I apologize.
Mr. Robinson, Ms. Fortier has advised that there was restitution that should have been addressed during the course of Mr. Williams' plea in this matter earlier today. Would that change the plea beyond that dollar amount for restitution?
No, oh, I'm sorry.
Mr. Robinson, go ahead.
No, Judge, it doesn't. I would just ask if I could just be sent the just the breakdown, and then we can, I guess, just put it. I don't know, Judge. Do you want to set it for a restitution hearing, or do you want to just wait till I have a chance to review it and talk to my client? I mean, it is what it is. So
should.
Yes, Judge.
Would it be most prudent to have probation send the victims a restitution letter and then based on their response, provide that information? Or Ms. Fortier, do you already have information on hand?
I'd like to place on the record, one, my apology. Two, it was the iPad that came in at the end was actually the victim. My victim advocate from First Step called me and indicated to me that that was the victim, that she had sent our victim advocate the restitution information, pictures, and the dollar amounts for property damage. And I apologize for that. It's my understanding, based on, I don't have the pictures and the actual the specific dollar amount. It's my understanding that it's $1,100 for property damage. So I don't know if I have no issue, putting this out till I can send Mr. Robinson the actual information, and then, whatever the court thinks is appropriate.
Mr. Robinson, I'm going to assume that Mr. Williams is no longer with you.
That's correct, Judge. I think he went back to work.
My concern, and I guess my only hesitancy to do that, would be that the restitution amount could impact Mr. Williams' desire to go forward in his plea.
Okay.
Not saying that that's necessarily the case, but that's a concern. So,
Yeah, I understand, Judge. I'm trying to think.
I suppose my question would be, Judge, potentially we reschedule for the next time that you're on the bench and I get Mr. Robinson all the information by then.
well, would that be a withdrawal of the plea or an amendment of the plea? Would that be solely a hearing on restitution, separate and distinct from his plea? Or would that be the basis to renegotiate the plea?
I just really don't know, Judge.
Judge, I'd be pretty. Judge, is there any way to go off the record?
Yes, sir.
Okay.